All right, everyone. Today we're answering two questions. First, why the U.S. Department of Justice letter about regulation by enforcement had a footnote that excludes a certain key rule, Section 1960, from their lighter touch approach. And second, why the tornado cash delisting from the SDN list hasn't been as straightforward as some suspected. And both overlap around what my guest today has called the most important issue currently facing the digital asset industry. And that was from a tweet a couple months ago. And we're going to talk about whether that's still true today. And joining me in this discussion is someone who I admire, Amanda Tuminelli, the Executive Director and Chief Legal Officer at the DeFi Education Fund. Amanda, welcome back. So good to have you here.
Thank you. Thanks for having me. Glad to be back.
This episode is brought to you by Day One Law, a boutique corporate law firm founded by recurring guest and friend of the show, Nick Pullman. Nick and his team at Day One Law provide strategic legal counsel to startups, crypto projects, and Web3 innovators. You can get in contact with them via the top link in the show notes below. So for those who might not be familiar, Title 18 of the United States Code is the main criminal code of the federal government, and Section 1960 is the federal money transmitting statute, which makes it a crime to conduct a money transmitting business without an appropriate state or federal license. So first question is, if crypto protocols never actually take custody of user funds, why would this be relevant to DeFi?
Well, that is the key question, just jumping right into the heart of it. So the short answer is that they shouldn't, but that is not how the DOJ has interpreted the criminal provision that you just mentioned. So just to back up for a second, Section 1960, as you said, is meant to be an enforcement tool for people who failed to register their custodial, I would say, money transmitting businesses with either their state or under the BSA with the federal government, the BSA being the Bank Secrecy Act. There is a provision of 1960, which is after the state registration, after the federal registration, which is 1960 B1C. And that is what we call the or otherwise provision. It's anyone who is operating an unlicensed money transmitting business who accepts funds that are otherwise known to be proceeds of a crime or used in illicit activity. And the DOJ has interpreted that provision very, very broadly, both in the case of the Tornado Cash developers and the Samurai Wallet developers. And at the DeFi Education Fund, our primary group that we are advocating for is our DeFi developers and DeFi users, right? That's who we care about. We want people to be able to build privacy preserving software. And what has happened with these prosecutions and with the sanctions on Tornado Cash developers and the smart contracts, which I know we're going to get to, is the government has made it essentially to build privacy preserving protocols. They've made it either a sanctions violation or a 1960 violation to build the kind of privacy tool that Tornado Cash is. So in 1960 specifically, the DOJ has interpreted these provisions to mean that even if you transfer funds or even if you write software that allows other people to transfer their own funds, you could still be found responsible for running an unlicensed money transmitting business. That is their interpretation of 1960 B2, what it means to have a money transmitting business. But to get all the way back to your question, I would say that there is no fair reading of 1960 B2 that includes non-custodial software developers or non-custodial businesses. It's just not what the statute is meant to capture.
And I think you are one of three people, along with Jake and Daniel, who can opine on that because you've actually gone back, then you've looked at all the case law and you've looked at what's happened since that rule was created. And from my understanding of that paper, you didn't find any case that said that this rule applies where there is no control or moving funds on behalf of a user.
That's exactly right. We looked at every case that has ever interpreted Section 1960. We include in that even cases that interpreted like the state licensing requirement and the federal licensing requirement, just to be fulsome. And we did not see a single case where the court interpreted a non-custodial service or product or whatever, anything into the TradFi world as equaling a money transmitting business. So this is a new interpretation. We had never seen it before the Tornado Cash indictment anywhere. And I think that makes sense, right? Section 1960 was written decades ago before instantaneous digital transfer was ever even possible. So how could it have been within the drafters' minds that this kind of tech was even on the horizon? I don't even know if there was a way to do non-custodial digital transfer like 20 years ago, right? So I think that it's just that open gap between what the law was meant to cover and how the DOJ has interpreted it needs to be closed. And I think that Congress needs to act to amend the law to make it clear.
Yeah, and from my perspective, if you built a highway and people use that highway to deliver cash to other people, now as the highway builder, you're responsible for what happens on that road.
Yeah, it is definitely hanging obligations and responsibilities on people who create neutral tools that have no ability to keep someone else from using that tool or control how that person uses that tool. That's why this is so problematic, is however you extrapolate from this DOJ interpretation, it's all bad for software developers. So if you create, like, technology is neutral, right? The Tornado Cash smart contracts can be used by anyone. You don't even need a front end, as people in the community know. So and as we've seen, right, like even with sanctions, people still use the protocol. No one can be excluded from it. No one can control it. So to suggest that you're running an unlicensed money transmitting business by publishing and deploying code that makes that available to everybody else is just completely nonsensical.
It's definitely a dangerous precedent. I think it's something that builders might not be aware of, and especially builders who may not be resident in the US, because we've seen cases where the US can claim jurisdiction through the server locations, through even something as simple as someone in Washington accessing the platform from Washington and then using that to claim jurisdiction. So there's definitely a lot of weeds we can get into there. But one just central point I want to double click on is the definition of money transmitting business. And how is that defined in the BSA? And does that matter for the DOJ's interpretation?
It absolutely matters. And under the BSA, a money services business, which includes a money transmitting business,
Thank you.
is a business that accepts and transmits funds. And that is clearer than 1960, right? If I accept your funds and then I transmit them, that certainly implies that I have control over your funds, right? If I've accepted them, that means they're probably in my custody, control, or possession after that point. And the BSA has been written that way for years. There are implementing regulations that assist people in understanding how to implement the BSA, right? And then there's FinCEN guidance released in 2019, which explained to the industry how they should interpret money services businesses rules in the context of software. And there's a section in the FinCEN guidance that talks about anonymizing software providers as distinct from anonymizing services providers. And what the 2019 guidance did so well was actually differentiate people taking custody, differentiate wallet providers or software developers who don't take custody and merely provide software to other people. And what's so dangerous about the way the DOJ has acted is they said to Judge Fela in the Tornado Cash case, we don't have to listen to any of the things I just mentioned. We don't have to listen to the BSA. We don't have to listen to 2019 guidance. We don't have to listen to FinCEN regs, because we're interpreting 1960 the way that we're interpreting it. And those things are not coextensive with 1960. So you have two branches of the government saying two totally different things about the same words. And it's really hard for me to imagine that Congress used the same exact phrase in two different statutes and meant different things, right? That just cannot be the case. So we focused on that in our paper. And we have been talking to many lawmakers and regulators about that exact distinction. And I think that the DOJ memo that came out a couple weeks ago now was trying to fix that problem. Like the fact that they titled the memo Ending Regulation by Prosecution, and that they did say we're not a regulator of money services businesses, right? They did address 1960, I think was them trying to acknowledge, like, we are not going to regulate. We're not going to say that we are the right people to enforce the BSA by having a different interpretation of the BSA. That's not our job. But they did have that footnote that I know you wanted to talk about as well.
Yeah, and before we jump to the footnote, I want to talk about the memo generally. And I think as someone who's been such an advocate for the space, you must be happy to see a memo like this come out, just to show that the DOJ as one agency is ending the regulatory weaponization against digital assets. Like, that in itself is a great first step. And there are nuances with the footnote that we'll touch on. The memo seems to disband a whole unit, ending the National Cryptocurrency Enforcement Team and requiring a unit within the DOJ's fraud section to seize crypto enforcement entirely. This align with is this a step in the right direction, or is this a bit of smoke and mirrors as to them actually doing something to end this regulatory weaponization?
Oh, I think it's definitely a step in the right direction. And I am grateful that this memo came out. I think even the title alone, like I said, is a big signal shift, right? So disbanding NSET it really does have real life effects. NSET was responsible for investigating and prosecuting digital assets cases, right? That was their bread and butter. So I think, not every potential criminal conduct category has its own unit within the DOJ, right? So I think that just having people whose only job it is to see crime in digital assets is a shift in the right direction, right? What's the expression? It's like to a hammer, everything
Yeah,
is a
I
nail.
was just thinking that. To a regulator with a hammer, everything looks like a nail.
Right. So I think that, and this is not to say that we don't think that criminals and people who are intentionally defrauding people or victimizing people shouldn't be punished. They should. The DOJ should go after people who are defrauding people and scamming people, 100%. But to have a unit whose only job it is to look for that specifically within the digital asset industry, I think is a misuse of resources. And I don't think this means that there will be no digital assets cases going forward. I just think that they will look different. And I think the biggest message coming out of that memo that matters is that they're not going after registration type cases. And that's not just 1960, right? They also said they're not going to be a securities regulator. They're not going to be a commodities regulator. So they're not just going to go after people for selling unregistered securities or running a trading platform where the only allegation is that they didn't register. So I think that is a big signal shift. It's aligned with the rest of the administration's shifts towards digital assets. And I think it is good news.
I think we could record this podcast just by giving you a microphone and the camera. You've been jumping through the questions for me perfectly, Amanda. So thank you. The next thing I want to talk about is this mens rea requirement when it comes to Section 1960, because there's this knowingly prong that's come up, and it comes out in the footnotes as well. In the footnote for Section, I think it's 1960 B1C. What does knowingly mean, given the regulatory uncertainty here and the novelty of DeFi, digital assets, etc.?
So there are parts of the criminal code where it's a strict liability. If you're doing the thing, it doesn't matter if you knew about the law or not, you're going to be prosecuted for that. So in 1960, there's the word knowingly in B1A. There is no knowing requirement in B1B, and then there's knowing in B1C. And this is because when the Patriot Act happened, the Patriot Act amended 1960 to add B1C. B1C didn't used to exist. And it used to be before the Patriot Act that not only did you have to know that you needed a license to run a money services business, you needed to know that you didn't have one. And that makes sense, right? Because if I don't know that I need a license and I know that I don't have one, that shouldn't really be news, right? But if I know that I need a license and I don't have one, then that makes sense to come after me and say you did something wrong. So it's a bit of a mess as it's drafted right now. But what this memo did is make it clear that the DOJ is interpreting 1960 as a whole to mean that you need to know that you need a license in order to be prosecuted, right? They applied the knowingly prong to B1A and B1B to make that clear. And I think that is a shift in the right direction. So now, if you don't know that you need a license under the state or federal law, then you should not be prosecuted for not having one. So that is a clearer distinction that the DOJ is making. I would like to see that codified, because this memo, while it is great news for us for the next 4 years, is not black and white law. And I'd love to see that be clearer in the law itself.
And it seems like the charge at the heart of the Storm and the Samurai Wallet cases is this idea that an individual knowingly conducts, controls, manages, supervises, directs, or owns all or part of an unlicensed money transmitting business that involves the transportation or transmission of funds that are known to the charged person to have been derived from a criminal offense or are intended to be used to promote or support unlawful activity. And in the cases like Tornado Cash, like Samurai, where you have a autonomous software that you're publishing, open source, people can build front ends, they can access it, etc. How does the knowingly prong work in those situations where you can't know it at the time of publishing, but maybe you happen to know it later on once it's out there and there's nothing you can do to stop it?
I don't know if there's an answer to that question at
Okay.
this moment, because it should be the case. It should not be the case that the DOJ can say that I did a thing 6 months ago that I had no idea was criminal, and now they've told me that it's criminal, and now I have no ability to react to that or do anything to comply, and so then therefore I am punished. That seems like a really bad policy outcome to me. It feels like when I do the conduct, I should have to know that it is criminal at the time that I do that in order to be prosecuted for it. But I think that you've hit on a really important principle at the heart of the Tornado Cash case, which is at the moment that the developers published the original smart contracts, they did not know that they needed a money transmitting business license, and they shouldn't, right? They shouldn't have needed one. So I think that that is the juncture at which we should be evaluating these things. And I think there's maybe a policy outcome or different outcome under sanctions law or money laundering law, right? But I think for the money transmitting business part of this, you should know that you're running a custodial business and that you need a money transmitting business license in order to be punished for not having one.
I think a big misconception with the crypto industry, and particularly DeFi in general, is people who aren't in the industry tend to think that crypto is looking for an exception from the rules, right? A way to sit outside of everything. And that's not, especially not what you're looking for here, where you're saying the rules can't apply legally as is to these situations. So we need to move forward and find other ways to make them fit the goals of the government in a way that doesn't completely hamper the industry, unfairly charge people for federal crimes that they didn't commit or don't fall under appropriately, in order to get a future that is a win-win for everybody.
Yes, exactly, right? You have a due process right to know what the law is before it is used against you, right? That's fair notice of the law, and that's supposed to mean something. It's supposed to mean that you aren't punished for things you weren't aware of, that you were doing wrong. So I think that, that should apply in digital assets and everywhere else.
And one thing you mentioned too is that you'd like to get this codified. And I think we're at such an important time now where if things aren't codified, we don't know, right? We can't guess what the future will hold, but there is a reality where things swing the other way and prosecutions begin again in earnest. A new enforcement group pops up at the DOJ, at the SEC, et cetera, and starts going after these projects who maybe in the next 4 years put their hand up or paint a target on their back by beginning to work with the government, collaborate, et cetera. What would codification look like in this case when it comes to Section 1960?
Yeah, so that's a really good point. Have many reasons to want durable wins for this industry, both in this context, in market structure, and other rules that may apply to the industry. But for 1960 specifically, I'd really like to see Congress amend 1960 to make it clear that 1960 B2, where it says what it means to be a money transmitting business, that it makes it clear that transferring funds on behalf of someone else means that you have to have custody or control over a person's funds. So to me, that is the most durable win. You amend the criminal code to make it clear, and then it doesn't matter who is in power or what administration we're talking about. That is very clear in the law. This memo does help, but it will only help as long as this administration is in place. So my concern is, like exactly as you said, we get a less friendly DOJ or a less friendly administration 4 years from now, and then we have to worry again about all the conduct that happened even during these 4 years, because the statute of limitations is long enough that the conduct that happens in this time period will still be up for grabs, 4 years from now.
I just want to quickly ask, how long is that time period for the statute of limitations for sections 1960 violations?
So in most cases, it's going to be 5 years. So it will look back to 5 years before the date at which the DOJ is looking to indict.
And that's such a relevant point for this particular period of time where developers are saying the DOJ is off my back. That might not be the case in 4 years.
Yeah, it should be that people don't have to worry about that, but unfortunately, I think they still do.
So let's quickly flip to Tornado Cash as just the last point. One thing that came out of the ruling from the Fifth Circuit was that OFAC overstepped their regulatory authority by sanctioning something that they don't have the authority to, which is a smart contract. But they subsequently delisted the Tornado Cash smart contracts from the SDN list prior to final judgment. And I thought that was an interesting thread, and I want you to expand a bit more on why that's so important.
Yes, and as you said, credit to my colleagues Laz and Gavin who did the deep dive for us on that. But I think what you hit on is the strategy that the Treasury employed, which is a litigation strategy, which is they tried to moot their case before they got a final judgment. I think that the Fifth Circuit ruling in Van Loon was very good in that it clarified that smart contracts are not property. They are not owned by anyone. And while they did make a distinction between immutable smart contracts and upgradable smart contracts, their ruling on whether something like Tornado Cash is considered an entity, I think the ruling on that was really good. They explained that a loose, dispersed group of people should not be considered an entity. If you haven't listened to the oral arguments in that case, they are extremely entertaining. The judge says something like, we're all wearing Rolexes here in the courtroom. Does that make us a Rolex entity? It's great. It's really like a very fun, not that long legal argument to listen to. But anyway, that ruling was very helpful. And what happened is after the circuit court rules, it gets sent back to the district court, and the district court is supposed to enter a final judgment that implements, like puts into practice the legal ruling by the Fifth Circuit and adds details and makes it clearer what the actual ruling is going to be. In between the time period of the Fifth Circuit's ruling and when the district court's supposed to enter final judgment, the Treasury Department put in another brief to the district court and said, hey, limit the Fifth Circuit ruling. Their ruling doesn't mean that we can't sanction upgradable smart contracts. It only means that we can sanction immutable smart contracts. And there's great matters of national security and all these reasons why you should not force us to vacate the sanctions that we previously issued. You should find something more favorable to the Treasury Department. Then after that, Treasury delisted, and it's not everything. Crypto Twitter would have you believe that they delisted all the sanctions on Tornado Cash. That is not true. They delisted the sanctions on the smart contracts and on the website. They did not delist the sanctions against Roman Semenov, one of the 3 developers of Tornado Cash. So what I take from that is the Treasury Department is saying to this community, you can use these smart contracts right now, but you can't build them. And that's a really bad outcome for software developers in this country. So in my opinion, the work is not done. But anyway, in addition to that, after delisting, they also put out a press release saying, in our discretion, we delisted the sanctions. Not we complied with a court order and this was the outcome of us complying with the court order. We made a mistake, right? They said in our discretion. How I interpret that is that they could exercise their discretion to relist sanctions if they decide that their interpretation is correct, that they could relist the upgradable smart contracts for sanctions. So anyway, they remove the designations and then they say to the court, the case is moot. There's nothing for you to decide here. You don't even have to issue a final judgment. And now we're waiting. We're waiting to see what the district court thinks about that.
And so if the district court approves that approach, if they decide to use their discretion again to put back on these sanctions, it's going to have to go back to the court system.
That's exactly right. Just from a matter of procedure, right? We're going to have to run it back and do this whole thing again. That's not a great use of everyone's resources. Like I said, Roman Semenov is still designated. If somebody wanted to challenge those sanctions, as a third party, it's really hard, if not impossible, to challenge sanctions against another person. Roman Semenov would have to challenge them himself. And on the smart contracts, we would have to find people who've used the smart contracts. And, Coin Center did this and the Van Loon plaintiffs did this, but they'd have to do it again. They'd have to find people using the upgradable smart contracts and say that that's not a proper sanctions designation.
I think the podcast could have a spin-off called This Is Not a Good Use of Everybody's Time and just talk about all the cases that we've seen that have fit that category. It'd be a long podcast series there. Amanda, the last question I have for you is about the DeFi Education Fund. I want to know, you're executive director now. We're seeing the industry shift from a period of defense to a period of offense. What do the next couple months look like for you guys?
Yeah, it's very exciting. I am so grateful that Miller put us in this amazing position where we have had direct contributions with lawmakers and regulators, and we've been able to have open dialogue with them, and we hope to continue doing that good work that Miller started. And we would just want to do more of it. We want to expand. We're scaling. We're hiring people. We are really excited to be part of conversations like the impending market structure legislation conversation to protect DeFi and protect DeFi developers and users. In our best case, we make it possible for DeFi to be built in this country and elsewhere without people worrying about criminal liability for things that they cannot control.
And we have a lot of lawyers listening to this podcast who might be interested in roles at the DF. Tell me a little bit more about the roles that are open and why people might be interested.
We are looking for a director of government relations and a senior counsel. And because I do know, like you said, many lawyers listen to this, we are looking for regulatory expertise. I was a litigator in my past life. I did white collar criminal defense and securities law, and I know what I don't know. And I would really like to hire someone who can fill in my gaps and knowledge and tell me all of their expertise about regulatory law. As we look at bill text, as we look at comment letters on proposed rulemakings, I would love to have somebody who is an expert and can issue spot for DeFi and say, this is a problem for DeFi technology, and here's how we fix it. That would be the absolute ideal.
And if someone who's listening to this fits that description and is really interested, how should they go about applying?
They should email us at careers@defieducationfund.org.
careers@defieducationfund.org. I'll put a link in the show notes below so people can see those job descriptions. And then I think I should be able to put in a contact link as well. So that will all be in the show notes below. Amanda, thanks for taking the time and best of luck with everything in Washington.
Thank you. It's great to be back. Glad you're doing this again.
All right. Thanks, everyone, for listening. That's another episode of the Law of Code podcast in the bank. If you're interested in learning more about our sponsor, Day One Law, you can find a link in the show notes below. We'll see you next time.